Rule 7, the rule that talks about communicating breach notifications. We are on that and we are going to talk about Rule 7 now. Welcome to my YouTube channel where you regularly see new content on data privacy. We are talking about Rule 7 now, which is about communicating the breach under DPDP Act. When does this rule apply? This rule applies the moment you come to know that there is a breach. It needs to be communicated quickly. There is no threshold time limit set by the board, but it is expected that you are going to inform about it to the data principals and to the Data Protection Board of India with no delay or without delay. No thresholds, no severity test, no harm based exemption. You cannot say that the breach was very small, it does not have an impact, so you can go ahead, does not matter. The breach data was encrypted, so even if someone has it, he can't use it. What does the need to notify? You have to notify the breach immediately. There's no excuse for it, and establishes mandatory transparency if you notify about the breach. What are the mandatory obligations? Data fiduciary shall intimate about the breach immediately without any undue delay. Each affected data principal and the board should know about the breach so that if they want to take any precautions, you might feel that there is no harm possible. Perfect, good. No one is interested in getting harmed as well. But then it's your legal duty as well as a practice that you should inform the respective data principals and board that there's a breach that has happened. You should communicate them the nature of the breach, the likely consequences, what are the mitigation measures that you have taken. For example, if the hacker came in, so now you have to understand from where did he come in, what was the gap in your network due to which you could manage to get in, and therefore accordingly you should take some mitigation steps, some safety precautions, and inform about that as a part of the breach notification. Contact details of your privacy officer should be there so that the affected principals can call back. Privacy officer does not necessarily need to be a very senior DPO, but at least a support center which can respond back when people call up to discuss about the breach and the possible impact. Likely consequences, consequently, whatever consequences have happened should be told to the individual. They have to be reasonably foreseeable that this kind of breach has happened. This could be the consequence. For example, the same example of credit card breach. If the data was encrypted, I can tell you that the possible foreseeable consequence is that after the breach, the people may be able to decrypt it, though the chance of decryption is 0.001%. If that was not encrypted, then I would tell you that your credit card information has been breached. If someone is able to read it, which he would be, and wants to misuse it, be ready or get your card blocked. Assess the possibility of the harm. We talked about harm assessment in the previous video, and document it and include it as a part of your breach notification. Common failures with respect to communication: you are silent, you are not responding, you are not even telling anyone. The notices that you are publishing are vague, they are not clearly explaining anything. You are just saying we are investigating, we'll investigate, and we'll let you know. And there's no over technical or misleading reassurance that you are supposed to give. Has to be clear, straight, technical, direct reassurance that you have to give to the principals as well as to the board. What you need to communicate and what you communicate needs to be documented. You need to keep copies of the notices that you have sent, the timing of the breach as well as the timing of the notification and the mode of delivery of the notification. What is the rationale for the consent choices that you have given, and how you protect if you are questioned later, right? So you retain the copies of the information sent out, breach notification sent out, record the timing of it, the delivery method of it, keep a rationale of the consented choices, and protect yourself if you are questioned later about the same. So as a summary, Rule 7 makes it more transparency for you. Communication of consent is in a prescribed format, quality and clarity comes up, and both of them matter. It's very important. Building trust, it cannot happen without clarity. So that's about breach notification rule 7 with respect to DPDP Act. I hope you like the content of the video. Please press the bell and the like icon, subscribe to my YouTube channel, and share your feedback in the comment section. Thank you.